Good afternoon, everyone. We're going to get started. My name is Josephine Hoegaerts. I'm Professor of European Culture here at the University of Amsterdam, and I'm very happy to welcome you to this afternoon's lecture, which will be delivered by a baroness, which is a very rare thing for me to say. I have to enjoy this moment. Maybe you don't, but I do. Shami Chakrabarti, who has been Shadow Attorney General for England and Wales, was the former director now of Liberty, an advocacy group to protect civil liberties and human rights, which will be part of the central issue we will be talking about this afternoon, in which he was especially campaigning against excessive anti-terrorist legislation, and she also was legal counsel for the Home Office. She is also the author of the book Human Rights, A Case for the Defense, which is, I mean, you get a slightly cleaner version if you buy a new one than my thumb-through copy, but and I think that is what she will be talking about most. I'm sure you're more excited to hear her than you are to hear me, so I'm going to vacate this podium immediately and leave you the floor.
We can clap, Josephine. That's allowed. They say you know you're getting older when the professors and the police officers and the prime ministers all seem so young, but that's the aging process. I'm delighted to be here. Thank you all for coming on this wonderful spring afternoon, evening in Amsterdam. I've called this talk Surviving an Intemperate Climate, because in the age of global boiling, which is the phrase you know that has been used by Antonio Guterres, the Secretary General of the UN, I think there's a direct relationship between the physical planetary environment and the political environment. And they interface in a way that is hugely pertinent to our fundamental rights and freedoms. So I propose, as you heard from Josephine, to draw upon the research and the writing that I did in my book, Human Rights, The Case for the Defense, to discuss this in the context of both international action on climate change and human rights being under threat. It seems to me that there are both challenges and opportunities in this relationship between human rights and the climate emergency. The threats to human rights from political repression of climate protests will be one aspect that I want to talk about in a few moments. So increased surveillance and suppression of protest movements, not just climate protest movements, but other allied movements. Migration is a massive issue in general, but is going to become more of an issue in the particular context of the climate emergency. But to begin with, I want to talk about threats and opportunities in direct relationship to how we address the climate emergency. So the opportunities. What are the opportunities in relation to utilising human rights in advocacy, campaigning, litigation around the climate emergency? The first thing that I would say is, like the crisis and like the corporations so responsible for exacerbating the crisis, and like climate science, human rights are international and universal. So they are, to no small extent, an international language, a language of negotiation, a language of advocacy, a language of law, but the language is international and global, like the climate emergency. And that creates an enormous opportunity, I think, in this connection between human rights and the climate crisis. Another enormous opportunity, and anti-human rights people don't like it, but I do, is that, let's be honest about this, you're a self-selecting group. If one of you turns out to be an enormous climate skeptic or human rights skeptic, I'll be delighted, and it will spice up the second part of the evening. But let's be honest, you're probably, in general, a self-selecting audience who are concerned about these issues. We will see. What I like is that human rights are, yes, they're universal, yes, they're values-driven, but they're also open-textured. They're capable of being interpreted to suit the needs of the moment. So, for example, Article 8 of the European Convention on Human Rights, which is one of the convention rights that has been most successfully used in the climate context, is the right to respect for your private and your family life and your correspondence. It's pretty much now a right to personal autonomy. And so there's an element of agency, there's an element of privacy, there's an element of autonomy. It's one of the rights that most fully encapsulates the foundational principle of human dignity. You know, when the convention was first drafted in 1950, not everybody could have anticipated that it would be used for data protection or to give us rights in relation to the internet or our communications data, because frankly, computing didn't exist in anything like the way it does now. But the right to respect for your private and family life and correspondence and your home was capable of being interpreted over the years to protect you from hacking your computer and mining and harvesting your data. Equally, not everybody would have supported family life, including same-sex relationships, but the court in Strasbourg and other courts in the European Convention system and elsewhere have made it quite clear that as far as they're concerned, private and family life does protect families of different types and relationships of different types. So this is what I mean by the living instrument. And it's not, that concept is not unique to the European Convention or even to post-war human rights. Even in the US, there I've said it, even in the US, where there's currently a bit of a retrenchment in all sorts of areas, the founding fathers could not have expected an unwarranted search, an unlawful search, to include all of this modern 21st century computer stuff, and yet it does. So even human rights hawks, even some of the most small c conservative human rights skeptics have got to accept that all constitutional and international instruments have to be capable of being interpreted over time in the context in which we find ourselves. And that is one of the great strengths of the human rights framework, including in this moment of climate emergency, which we didn't anticipate in 1950. It was at least 30 years probably before we started really being aware of that. But that open-textured human rights, values-driven framework is capable of helping us address new challenges, new contexts, new technology, new science, and so on. So that's a great opportunity. We've also seen that human rights law, and by the way, human rights is not just about law, but human rights law can be blended. It's a bit like making a cocktail or a scientific experiment. Human rights law can be blended with other types of law, the law of tort, environmental law, constitutional law, even potentially corporate law, to create a more potent cocktail, to create a legal force with greater sharper teeth, greater potency, an ability to hold governments and maybe even corporations more closely to account. And then finally, as I said, human rights are not just, in my view, about law, which is why I'm delighted to be having the conversation in a moment with Josephine, who's a historian. Human rights live in the world of values, primarily, of personal ethics, of collective morality, of politics, and yes, of law. But they're not just about law. And that's really important, I think, because we have to deal with something like the climate emergency in all of these spaces as well. There's nobody who thinks that you can just deal with the climate emergency by law alone. It needs so many other animators, which we'll come to. So that's the sort of positive beginning, that there's a real opportunity to use human rights values, language, law, norms to help us navigate the crisis. But there are challenges as well. And an enormous challenge is that just as there is climate skepticism, it's not the majority opinion. The majority opinion on the planet is probably now pretty well established that we recognise global warming since the Industrial Revolution. We understand that it's man-made. We understand that it's unsustainable and that we have to do something about it, or we are bringing our race, the human race that is, not a specific group, not a specific ethnic group, you understand. We're going to bring not just the human race and so many other beautiful creatures, but our planet to an untimely end if we don't address it. That is the majority opinion, certainly the scientific consensus on the planet, but there is a significant and powerful minority opinion that is very sceptical. And if it isn't sceptical about the emergency itself, it's certainly very resistant to the politics and the economics of addressing it. And now we're into the culture wars, because some of those same skeptics are equally hostile to the notion of human rights. And this was not always the case in the post-war period at all. There was, for many years, a very healthy centre-right and further right, conservative, small c and large c conservative thinking around conserving the land, the planet. But that is in retreat in the current political context, I would say, in Europe and in America and elsewhere. And when you put these two culture war hot-button issues of rights and freedoms of human beings on the one hand and dealing with the climate emergency on the other, when you put them together, that is a pretty toxic cocktail for some people and very inflammatory, and they really don't like it, and it makes it very, very difficult politics. So that's a challenge. Another challenge of using human rights in the climate debate is that corporations are not directly bound by human rights treaties. I think this is a massive problem, and not just when it comes to climate change, but when it comes to war and the arms trade, when it comes to tech and AI, when it comes to vaccine inequality, when it comes to inequality, we've got this massive, massive challenge with corporations who are bigger than governments, who have Byzantine legal arrangements that make them very unaccountable. They can incorporate in one country, operate in another country, have shareholders everywhere, have consumers everywhere, with all sorts of conflicts of interest. But there's a huge accountability gap there. That is a challenge. And human rights treaties and laws bind governments rather than corporations. Corporations have outgrown their makers, like advanced AI. So even before advanced AI, we designed instruments that would become out of control, and the corporation, I think, is an example of that. And that's a massive challenge for dealing with the climate crisis, and certainly in relation to human rights. Another challenge is, as I said earlier, law is not enough. you cannot deal with this without a great deal of politics and advocacy and economics. And if you try to do too much by litigation in particular, you risk a backlash. You risk delegitimizing the rule of law because the skeptics and those who are hostile to what you're trying to do say that you're hijacking politics by, putting on a judge's wig and there's a democratic deficit, etc., etc. You know those arguments. And ultimately, the problem is that green is the new red. Ultimately, let's be honest, the big political problem is that we cannot have a just transition of a kind that respects the rights and freedoms and the human dignity of people all over the world, particularly in the global south, particularly in low-lying island nations and elsewhere where the impact is faster and greater. You cannot do that without an economic reset. In relation to very wealthy individuals, in relation to corporations and so on. That's hugely political, and that creates an enormous challenge for trying to deal with this in the legal space as opposed to a more obvious political space. So that's a sort of summary of the challenges and opportunities. I want to talk a little bit about the ancillary issues of protest on the one hand and migration on the other. So this now isn't about taking cases to the Strasbourg Court or the Human Rights Committee to force governments to better address the climate emergency. That work has been very innovative and reasonably successful in recent years. Right up to last year's Swiss grannies case in the Strasbourg Court, but again with a backlash that follows. The idea that you can take something like the Paris Agreement, which is pretty weak in terms of not having specific binding legal targets for your emissions, you take something like those aspirations and combine it with the right to life and the right to private and family and home life. You put them together and suddenly you've got something much more potent, as we've seen, we've seen in the Dutch courts, we've seen in the Strasbourg Court. So, that's the business of using human rights to advocate for measures to address the climate emergency. In the meantime, there's the other side of the balance sheet. And that is that corporations and governments have stepped up their surveillance and their repression of climate protest movements in particular, but protest movements in general, and they're doing this all over the world. And this is well monitored by Amnesty International, by Human Rights Watch, by specific local NGOs all over the world. Greater repression of these protest movements, and some of the laws that have been introduced, particularly I would say in the UK, but I've got a particular observation of that. Some of them very closely mirror anti-terror laws. So some of the laws that we saw post 9/11 to deal with terror suspects are now being used on even non-violent protesters. Certainly in the UK, where it is now a criminal offence to attach yourself, attach not defined. So it could involve linking arms with somebody and singing Kumbaya. Okay, so you attach yourself to another person or property or land, and there's a risk that you'll cause a disturbance to a few people. That's now a criminal offence in the UK. And noisy protest has been criminalised. So it's not about damage to property or damage to people anymore. It's about disruption. And we also, in addition to these offences, criminal offences that target behaviour that would normally be considered innocent, like carrying a bicycle lock. Putting a bicycle chain or a bicycle lock in your rucksack could now be equipped to lock on, to attach yourself. So on the day of a big climate protest in London, anybody who's carrying a bicycle lock could potentially be guilty of this offence of being equipped to lock on, whether you lock on or not. And then with the new offences come stop and search powers. And some of the stop and search powers don't even require reasonable suspicion that the person is guilty of that minor offence. So you see this pattern, and then you have other issues like civil orders that criminalise somebody. I give you an injunction, you breach the injunction, but now it's a criminal offence. So this whole apparatus of powers previously used for terrorists and suspected terrorists now being applied to climate protesters and to other protesters. The positive side of that pretty chilling situation is that there is a coalition of different protest groups, Black Lives Matter and Extinction Rebellion, pro-Palestine protesters, trans rights protesters who see the repression of all of their rights and come together. But the political action against peaceful protest is very, very concerning. The other side of that is surveillance. Now, it is clear in the UK that since the 1960s, the then Labour government, led by Harold Wilson, started using undercover police officers to monitor civil society groups. Not foreign agents, not violent groups, but trade unionists, environmentalists, anti-Vietnam protesters originally, and that those units of the police carried on in successive years. And this culminated in what we call the Spy Cops scandal, where police officers from the Special Demonstration Squad were allowed to go undercover for years on end and form intimate relationships with people, including women, father children, in an alias. And this is very, very dangerous because, of course, you can put a listening device in somebody's home, but if you actually put a human agent in somebody's home or friendship circle or political grouping or bed, you're changing their behaviour. So you can very easily be an agent provocateur. You're not just monitoring or surveilling, you're actually initiating and inducing people potentially to break the law. And the idea is that you will disrupt and possibly even defame a normally peaceful group. And we have an enormous scandal that is unresolved in the UK. There is a public inquiry that is taking years, called the Spy Cops Inquiry, and we've had the first part of that report that covers the early years, but we still haven't covered the later years, and in particular the proper Spy Cop scandal involving these women in the environmental movement who had children and so on with undercover police officers. And in the meantime, Boris Johnson's government response was to legislate to actually grant immunity from criminal prosecution to not just undercover police officers and spies, but their agents, who could be criminals that the police or the security services have paid to be part of their network. And now, for the first time in UK law, there is a mechanism for granting these people immunity from criminal prosecution. So you send somebody into an undercover operation and they know in advance that if they do various things, they will not be prosecuted. That's, in my view, incredibly dangerous. So the clampdown on protest is a massive problem in this space. And, you know, over time, it won't just be a problem for environmentalists being arrested and detained and prosecuted. It could just as easily be communities that are concerned from the other side of the equation. The people who don't like the low traffic zones, the people who don't want their oil refinery to be closed down because they're worried about their jobs, just as striking miners did in the 80s. It could go either way, but the point is it's bad for rights and freedoms, and it's bad for democracy, which isn't just about voting every 5 years. It's also about being able to express yourself and change the conversation in between elections. And it's a safety valve. So that is a problem. And then I would also say that the elephant in the room is migration. Now, we know already, if we're talking about culture wars, if we're talking about people who don't like dealing with the climate emergency, if we're talking about people who don't like human rights, they're often very, very anxious about migration. And the Refugee Convention, which was effectively the world's apology for the Holocaust, it's the most specific and direct response to people who were not able to escape the Nazis and died even when some of them tried to escape and weren't given safe passage to places like the UK. The most direct and specific post-war response to that horror was the Refugee Convention, where it's accepted. It is hard law that if you are being persecuted because you're a member of a particular group and you're being persecuted for a convention reason, you should have your claim considered in the territory that you arrive, and you should not just be turned back without that proper consideration, and you should be granted asylum. We now see, as you will have noticed, countries all over the world who are pushing back on that traditional obligation. It was fashionable in the 80s, even in right-wing circles, because refugees were Russian ballet dancers and defecting spies, and they made us feel good in the West about our free society, and it was these Soviets who were escaping. Refugee was a very, very noble word in those days, less so now, because now it's people from the global south, from Afghanistan and Syria, and they're not all white. Let's be honest, it's a massive challenge. And you see European countries, you see the US, you see other countries reneging on their Refugee Convention obligations. Now, here's the problem. That's even the Refugee Convention as it is. It will be even more strained by the climate emergency. We use the phrase climate refugee to describe somebody who needs to move, who needs to escape a hostile physical environment rather than a political one. This group of people is only going to increase as time goes on, but the Refugee Convention is not very well suited to people who are escaping that kind of physical environmental problem. It's not always persecution. It would be very, very difficult to put all of those cases into the rubric of the Refugee Convention. And so until there is enough international leadership and agreement to draft a new convention to deal with climate migration, we've got a real problem. Now, as human rights lawyers, there's already the beginnings of creative responses to this, because the principle of non-refoulement, non-return, not sending somebody to their death or to an awful experience, is not just in the Refugee Convention or the Torture Convention. People argue that it's now a principle of customary international law. You do not send somebody back to their imminent peril. And that has already been argued in the climate emergency context in a case against Australia in the Human Rights Council. But it really does require a very, very imminent risk to the person. And we don't really want to wait until that risk is so imminent to hundreds and thousands and millions of people. So there's a real, real challenge in the relationship between the emergency and migration, particularly given the scepticism that we've been talking about in relation to human rights and the basic idea that all human beings are equal in their dignity and their worth. So those are sort of my introductory remarks. I hope that in a little while, after Josephine and I have had a bit of a conversation, you'll have your own thoughts, your own questions and comments, and my favourite, by the way, which are comments very thinly disguised as questions. You know how to do that. You basically say, I think blah, 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 don't you agree? And that's a question. That's fine. And of course, if you're Australian or French, it's even easier because you don't even need to say, don't you agree? You just raise your voice at the end of the sentence. But I do hope that we get the opportunity for a bit of a discussion after Josephine has opened things up. But in the meantime, thank you so much for coming and thank you for listening.
All right, thank you very much for that very rich talk where we had a number of different really important topics, I think, and I would like to address them all, but I won't. I will leave some room for all of you to ask questions as well. I maybe want to start very broadly and pick you up on something that is both in the book, but you now also mentioned as well, is the sort of the way in which human rights language works to a degree. You've defined it as an international language, but also as a sort of, and I think in the book you write it's very sparsely and lyrically written. There's an almost poetic quality to how human rights are sort of written down. And I wonder who or what that then really speaks to as well, right? So who is addressed to a degree by this particular language of human rights? And maybe also in terms of that, the kind of choices that are made in how human rights are written down, because I think most of us would think of human rights much in the way that you described it now at the end of your talk as a sort of, a sort of framework in which we think about the equality of human dignity. But equality is barely mentioned in any conventions of human rights, right? The language of human rights is very much about freedom and has that sort of almost poetic quality of what freedom then represents. So I wondered if you could comment on that and sort of what that achieves, I guess.
Well, thank you, Josephine. So one of the challenges, I think, is that, we've had different historical waves in the world in relation to people's struggles for rights and freedoms. And it's very convenient for people of certain politics to try and separate, older struggles that they think are in the individual nation states. They try to separate those struggles from the later, more international struggles. So it suits some people in America, in Europe, to say, proper freedom struggles were a long, long time ago. And there's a total break in 1945, or even later in the 1960s. And all this international stuff is a confection, is a fabrication. The real stuff, if you're English, is Magna Carta, where the barons told the king that they wanted to be tried by their peers, et cetera, et cetera. And they want, so it's partly nationalistic, because they don't want anything to be too international, because that has consequences if we start respecting the rights and freedoms of people wherever they're born. That has implications that we don't always find attractive. So we want rights for free-born Englishmen, but nothing for the refugee. So that's part of the challenge. And then another part of the challenge is we want freedoms but not positive rights. So where there are people to the right of politics in particular who are perfectly happy with freedom from state interference. So the state shouldn't be able to falsely arrest you or enslave you or torture you or whatever, but don't go asking the state to positively lift you up and protect you from neglect and abuse, because that costs money. And anything in the tax and spend area is not good. So we want freedom from state interference, we don't want freedom too. But in reality, this is nonsense. It doesn't make sense in practice. You know, what is the point of a freedom from torture or a freedom from state abuse of whatever kind if you don't have access to justice, which involves public spending in the justice system, actually involves interpreters and lawyers and legal aid and court buildings. You know, this idea that you can have a total separation between freedom from and freedom to is nonsense. And as it's a nonsense to say, I believe in free speech, but I don't believe in a right to food or shelter. You know, human rights are supposed to be about protecting everything that a human needs to survive and thrive in the world, which is very pertinent to the consequences of climate change. So yeah, it's much more attractive to some people to use the language of freedom than to use the language of rights. And on the international point, I would say that you're a historian, Josephine, you know that it is nonsense that older struggles were only ever nationalistic. You know, the idea that struggles for women's suffrage or struggles against slavery were based in one country or another is a nonsense. There was also a great deal of collaboration over the American and French revolutions with philosophers and thinkers and activists sharing expertise and knowledge. So, you know, there was internationalism a long time before 1945. And I think that we need to revive those histories and those stories because the narrative is very, very highly edited.
Yeah, there's a very interesting quality, I think, in these texts of human rights, is that they borrow freely from older rights and bills of rights, but then translating those concepts into what they think is a completely new context, but which, of course, is a very specific one after the Second World War, and then doesn't always, I think, translate very well into current-day kind of problems. I wanted to maybe move towards sort of more a specific, you know, how human rights is a sort of useful framework to think about the climate crisis, and I'm wondering particularly what you think the role of protest is in that. Because I think you sort of see two things. On the one hand, you have protesters who really seem to draw issues of human rights to the center of attention by protesting, right? By making it a problem of surveillance, by making it a problem of free speech. But by the same token, of course, there is an issue of human rights in terms of the unequal results of the climate crisis, and those rights perhaps are less televised or are less present. So I wanted to ask you what you thought about the role of protest, particularly in making human rights work for us, or maybe even work for the climate.
Well, in relation to that, you know, I think the coalition that I saw a few years ago between, say, Extinction Rebellion and Black Lives Matter during the pandemic was very important, because certainly in London, you know, the Extinction Rebellion protesters, if you just looked at a crowd of them in Parliament Square, they were nearly all white. And then the Black Lives Matter protesters were nearly all black. But because all of their protest rights were being interfered with, they formed a natural coalition. And I think we will see more and more of that. We will see the race equality movement come together with the climate movement on an international scale, because of all the diasporas, because of the internet, because of the way that we are so interconnected, not just by climate but by information. You will see these alliances. You will see people, just as people care about what happens in Gaza when they don't live in Gaza, but they can see the images of what's happening. You will see people caring about what's happening in the global south, in low-lying island nations, and so on. But the point you make is that the really important point is that there's all this talk about freedom, but the real key to the human rights kingdom is non-discrimination and equal treatment. And it's not always foregrounded in every instrument, in some instruments more than others. But the key to the human rights kingdom is equal treatment. Why? Because most rights and freedoms are not absolute. You know, the right not to be tortured is absolute. But most other rights and freedoms, like privacy, like free speech, like freedom of association, can be proportionately interfered with by the government for the purposes of protecting other people. So what stops the government of the day just picking and choosing who to pick on? The important protection and discipline there is equal treatment. And the courts, you know, the courts feel quite confident in the space of discrimination because they don't see it as pure policy. They see that there is a role there for jurists in protecting minorities from that unequal treatment.
But this is, so I find this really interesting, this notion of how equal treatment is then written into human rights, but then also how it is, you know, processed by lawyers or by jurists in a more general sense. And one of the beauties, but also one of the problems, I guess, of the human rights language is, again, that sort of lyrical quality it has, where it doesn't necessarily, I think, communicate that absoluteness in every case in equal measure. You know, equality is not something that human rights seems to be interested in if you read the text, even though it is central to what it is trying to achieve, which, again, I find really interesting. And so one of the, I teach a bit on human rights as a non-lawyer, which makes it really tricky to do in many ways. But one of the central questions I always start with students is to ask, who is the human in human rights? And somewhat atypically for a legal text, that is not defined, right? There is no definition of who is being protected or who is being addressed. And in terms of equality, that's an interesting question, particularly, as you mentioned before as well, as we're now entering an era where non-human entities have enormous impact on the world, right? How do corporations fit into this? How do animals fit into it? How does AI fit in? So who is the everyone that human rights is trying to sort of really address there?
I think the everyone is every human. And then obviously we have very difficult issues at the beginning and end of life. We have all of those discussions and debates and problems around the unborn child, which has caused enormous problems in Latin America, in the American, the inter-American human rights framework, and why you don't have Canada and America and all of that, which mercifully hasn't been such a problem in Europe, despite the different views about abortion. So it's everyone is every human, with these caveats about these very difficult caveats about when life begins and when life should end and all of that. You're quite right. It is not animals. It is not robots. It is not even the physical environment. So when you use human rights to help advocate climate protection, you're not advocating for the rights of plants or the rights of other creatures, but you are advocating for the right of any newborn baby anywhere in the world, whether in a Syrian refugee camp or anywhere else. You are advocating for that, and you're pegging action and demands onto those rights. It's not unborn generations, though that language begins to seep into the jurisprudence, and we may see more, who knows, we may see more of that, because the human may be the human race and the human species even looking a bit further forward. But there was always, but at least the post-1945 framework is about everyone. It's not the barons, and it's not men as opposed to women or people of a particular race, even if in the post-war period this wasn't honoured in practice. In apartheid South Africa, in Jim Crow America, let's be honest, we're talking about ideals that are often dishonoured, but I still think they're a potent force.
Yeah, and I think it's very much this sort of universalist claim, of course, that underpins, and which is very particular, again, to that moment of post-war Europe, of thinking in those universalist terms. I want to maybe try and come up with one last question, and that's because you brought it up a couple of times in the talk as well, is how human rights then connects to individual identities, particularly when we think about the current context of culture wars, where people, of course, have very different ideas of what constitutes an individual identity and what then, in a sense, constitutes their right to claim particular freedoms or their right to claim particular rights. Do you see a sort of threat there to that universality of the human in human rights, and how does that play out in practice then?
Well, by definition, culture wars are an enormous challenge to the human rights framework. Because if you believe in human rights, you believe in human dignity, you believe that every single human being anywhere in the world, newborn baby, aging person, everybody is entitled to their human dignity. If you're a culture warrior, you have a different take, and things like race and nationality and sexuality and political identity become sort of trump that universalism, and that whole way of thinking is very potent as well. So I'm saying I think that this concept of human dignity and equal worth is hugely potent. Well, goodness me, we know from the Tea Party, we know from the far right all over Europe, we know from Trumpism that there are other ideas that are just as powerful. And of course, and they work very well for some very, very wealthy, powerful people, because you can say to the bulk of people on the planet, yes, you feel hopeless, yes, you feel poor, yes, you feel you haven't been properly treated, but blame the refugee and blame the trans person and blame whoever it is. Don't blame Elon Musk. Don't blame the wealthiest corporations and people on the planet. Blame your neighbour if they are the wrong sex or race or sexuality or whatever. That is the beauty, that is the attraction and the danger of culture wars. And it's very easy, even for quite progressive people, actually, to fall into that trap. And the trans debate is a very obvious example of that. Women of a certain age who fought for years not to be reduced to their biology, who fought for the contraceptive pill, who fought for abortion rights, now defining themselves, often in their post-reproductive lives, defining themselves by reproduction and biology in a very strange way. But these are quite progressive people who are falling into that trap, which I think is ultimately about victimhood.
And contextualizing identity rather than universalizing it, yes. I mean, I feel we could talk about this issue for quite a while yet, but I want to make sure that everybody else gets a chance to ask some questions as well. So let's open this to the floor. Can I have one or two questions, please? At least one there, yes. Yeah.
Yes, thank you. A month ago, I was on the Zuidas, in the heart of the big money here, with two professors, 400 students. They analyzed the top 25 stock exchange noted companies in the Netherlands on social and ecological and financial values. The financial value we know, everybody knows, because it's in their annual reports, the financial. But the analysis say behind every 100 euros of financial value, there is 200 euros of ecological and social damage. Dus bottom line, there is a minus. Is it also that this kind of transparency can help start discussions, what we talk about, if you talk about real values, that was the subject of the meeting, and hopeful that we can say that we get, maybe we also address it as an elephant in the room, that we have to get rid of things that damage us more than it added value.
Yes, it is a question. I think it is a question. It's whether I think the question was whether that kind of transparency around corporate activity and corporate value and the measurements that aren't just financial measurements, whether that can be helpful to the kind of causes that we're talking about. I think, yes, in principle, that kind of discussion and that kind of transparency, corporate transparency, has got to be a good thing. But there is a but, which is greenwashing, pink washing, rights washing, where you go on the website and you see, you know, the arms company and the fossil fuel company, you know, showing you pictures of lovely boats in the Mediterranean and all the lovely things that they're doing. So it's not transparency by itself without some independent scrutiny and even enforcement may not be enough, because transparency can so easily be not really transparent but a kind of sales pitch. But in principle, I have to agree with you that we need to... The thing about companies are creatures of the state. You know, people choose to incorporate a company rather than operate as a sole trader because it makes sense to their business. They get certain advantages in the way that they can, whether it's limited liability or the way that they can organise or the way that they're taxed. You know, and the state sanctions companies and governs taxation and corporation law and so on. And so I think transparency is one thing, but I think I would be more radical even than transparency and say that there should be other positive obligations and injunctions on companies to do this and not to do that. And we should be looking at them in terms of their international operations and their supply chain and how they treat their workers and so on and so forth. But of course, ideally, you need concerted international action. Otherwise, you get the argument that, well, you know, if you start clamping down on this in the Netherlands or in the UK, they'll just go and incorporate it somewhere else, which is why something like, you know, the European Union has a potency, because it's a bigger market and a bigger group of nations. But yeah, in principle, I do agree with you.
Thanks a lot for the talk. I have a question that is particularly pertaining to the climate issue, which is related to time in general. And how does it play out in the human rights context? We've been discussing this morning as well in classroom about the Klimasenjorinen case, the Swiss lady case, and also you mentioned the case, I think it's Torres case, about the climate refugee. So I think with this issue of risks, right? How courts also perceive the climate risk, which is on the same time apparent, but it's still at the same time also far away. It's kind of in this limbo, right? And for the human rights perspective, it seems to me that in order to operationalize, in order to enforce sort of human rights and to be successful in court, you need to show that the risk is there and it's affecting a climate refugee or a particular group of people. And how do you navigate this tension there? Because you hinted at that before. And I see that from a lawyer perspective, this is a bit problematic in how you put it in a human rights context. Whereas in other contexts, is a bit, even in the environmental context, is easier to show that there is an imminent risk. I think about accidents, think about all kinds of cases that are brought before European Court of Human Rights. There is this tension, and time is limited. It's running out, basically, in the climate change context. So, yeah, how do you see this from the perspective of human rights in this case?
I think it's a brilliant question, Matteo, and it's not just a legal problem, it's a psychological problem. It's how we deal with risk as human beings is a really, and how different groups of human beings deal with it, whether you're an insurance company or whether you're the mother of a small child, or whether, you know, this idea of how much risk is acceptable risk and who bears the brunt of the risk, who really carries the can for the, you know, this, and there was a book that I read when I was writing mine. It's not a law book or a human rights book. It's called Immoderate Greatness by an environmentalist called William Offals, I think. And he uses this concept of immoderate greatness to describe a kind of hubris, this kind of humanity develops, we're amazing creatures, we come together, we build these amazing empires and cities and whatever, but we look the other way from the great big inevitability that is death. And maybe we should, because if we all thought about death the whole time, we'd be very miserable and we wouldn't live our lives, right? So there's a kind of natural optimism and resilience in the human species, which is really powerful. But if you take it too far, it becomes the death denialism. And I think that a lot of the people that I listen to in UK politics who do not want to deal with climate change, they don't want to deal with their own mortality individually, let alone deal with potential collective mortality. And so it's very easy to look the other way from something that will happen after I'm gone. Maybe my children, maybe my grandchildren, maybe people in the global south, and so that what is resilience 1 minute, which is, I'm a great hero who will fight a war and win a medal because I'm brave and I don't care about death, that kind of instinct can also lead to some really stupid, rash decisions on an individual and a collective basis. And it's not just a legal problem, it's a psychological, sociological problem. But in legal terms, there is this issue about how imminent a risk has to be, and we see it in some of the case law around the right to life in particular. How imminent does the threat have to be before you can't return the person to the physical hostile environment? But I think what has been helpful more recently is the combination of the scientific consensus on the one hand and the governmental consensus around Paris. So even though governments have been slow to put the proper targets and the binding targets, the fact that they have agreed on the science and the need to cut emissions is then something that courts can seize upon and blend with the right to life, the right to home and family and so on. And this kind of cocktail, this kind of blend of these different legal frameworks can sort of help. But you're right, this issue of risk and the timeliness of the risk is a problem. But, the clock is ticking and we're running out of time. And I think it's not just you and me that think that.
I think we have, one more question in the back.
I'm going to cheat a little bit, 2 questions. First is what your position is on nuclear energy, and then the second one, UK Supreme Court recently ruled on a definition of what a woman is. What's your position, and do you think Labour, which my understanding is that they might contest that? Could you elaborate?
So on nuclear, remember, I'm a lawyer, not a scientist, okay? So I'm not really qualified to opine on nuclear power. But I do know that this is an issue that splits the climate movement. And there's an element of there's an intergenerational element to it, but there's also, there's a live debate. And for a lot of people, this is clean energy, this is part of the solution, this is part of weaning us off fossil fuels. For other people, it's dangerous, and you need a scientist, not a lawyer, to sort that out. But for a lot of people, including in the environmental movement, including in Europe, this is one part of weaning ourselves off fossil fuels. But it's really an issue about safety, isn't it, primarily? As I say, I'm not best qualified to opine on that. Yes, last week, the Supreme Court of the UK ruled on the definition of woman for the purposes of our Equality Act. And it ruled that a woman in the Equality Act is a biological woman. What does that mean? It means your birth sex. And in the culture war environment, this was applauded by a large part of the media, actually, the mainstream media in the UK, and lots of politicians, not just of the right. And I think it's very sad. And I disagree with the judgment. And I think the judgment was billed, respectfully I disagree, because I don't believe in bashing the referee when I lose a match, and it's very dangerous to denigrate the judiciary in these times, but I think it was a real mistake. And the judgment, you can look at it, is sort of shrouded in this very, very dry, legal, academic language, as if it was pure statutory construction, and there's no policy and there's no politics in it. But if you read between the lines, there's a lot of policy and a lot of politics in it. And a lot of this so-called statutory construction is really about the judges saying what they think perverse outcomes would be. And I think they've come up with quite a perverse outcome where you're supposed to use one kind of facility and not another, no matter how far you've transitioned. And the consequence of the judgment is not just about the direct effect on whether somebody, can't use a woman's bathroom in a restaurant, or I mean, who puts police officers outside public bathrooms anyway? It's really more about the political climate and the social climate, and how trans people, who are a tiny minority of the population, feel about their dignity and their safety in a political context where they've been too much in the news. When you're in a vulnerable minority, you don't want to be in the news the whole time. You don't want to hear people rowing about you. You want to live your life with peace and dignity and safety. So I think that was a very, very troubling judgment. And as with all culture war issues, it splits the left and progressive parties much more than it does the right. The right are all laughing, but certainly I'm in the Labour Party, and I know that people have divided opinions about it. I am a woman, I am a feminist, but I'm a human being first and foremost, and that's really what human rights are about. And I certainly don't think my feminism or my womanhood is defined by pure chromosomes or reproductive organs, or I think it's very reductive, that narrative. Well, you can't contest the Supreme Court. I mean, a group of trans people could potentially go to the Strasbourg Court and say that as a result of this interpretation of the Equality Act, they are now discriminated against. That could potentially happen. But in terms of legislative, political change, there doesn't seem to be a huge appetite for it in the government at the moment. And the context there is you have a Labour government, but you also have the rise of this Nigel Farage Reform Party. And so this kind of social conservatism is very much an issue.
I think I saw one or two hands there, right? Yeah.
Yes, thank you so much. I wanted to ask a question about preemptive legislation, because you mentioned that a lot of the legal bases which we use today to tackle the issues of AI or technology have been created decades and hundreds of years before, and they were not intended to be used in this way. So please tell me your opinion. What do you think? How feasible may it be for us concerned with matters of climate change and all the possible implications derived from that? How feasible it is for us to attempt to legislate preemptively to target such concepts as the climate refugee and all the further terms, while there is no backlash to tackle those problems, or while there are no interested parties who would be opposing those because it targets their interests. If it is clear.
So what I think is that it is possible in drafting terms, in philosophical terms, in creative terms and intellectual terms, it is possible to draft for the future, to imagine the future, to not just imagine, but we know there are going to be climate refugees. There are already. We know this is going to increase. So it's not a problem of drafting or imagination, it's a problem of political consensus. And achieving that political consensus is so difficult at a time when so many people are pulling back on human rights, pulling back on universalism, and not even honouring the Refugee Convention that we currently have in relation to persecuted people. So we've got a political challenge there rather than a legal one. And so what then happens is you have campaigners and campaigning lawyers and others doing what they can with the tools that they have. And so, and then you get the backlash, which is you're stretching the existing law, you're an activist lawyer, you're usurping politics with your creative interpretation of the law. So this is the tension, this is the conundrum. But there's no right answer to that. That's a constant discussion, a constant dilemma, a constant challenge. But what I will say is, if the politicians and the statespeople don't step up to actively draft new treaties to deal with these new situations, they cannot blame others from using the tools that they have to try to respond essentially to save people's lives. But in an ideal world, human rights live in the political sphere, including the international political sphere. They live in the courtroom, they live in the law school, they live in the newsroom, and they animate all these different areas of life in an ideal world. And law and politics sit side by side. There's never been a bright line or an absolute distinction between law and politics. Never. Ever. But we need human rights values to be in both. And I think that, Josephine sort of touched on this earlier, you have these 1950 instruments and you think, well, that doesn't really work for this particular challenge. When we're talking about things like war, tech and AI and climate, there's no doubt that we need new treaties and new rights in my mind. Because some of these things were just, some of the technological stuff and the climate emergency were just really not in proper contemplation. And I do think that we do have to be honest about the fact that we could do with extra protections to deal with some of these challenges. But there's still a lot that you can do with existing instruments. When you're talking about tech and AI, our existing rights and freedoms not to be degraded, not to have our privacy intruded on, etc., are all being abrogated in the online space. And the problem is not the law, it's the lack of resources, enforcement, political will, corporate will to actually tackle the abuses that are happening online. There's a lot you could do, even with the ECHR framework, to deal with online abuses that isn't yet happening but might yet happen. But over time, I think there should be new treaties. There should be an internet treaty. There should be treaties, just like we have treaties on arms proliferation. There need to be treaties in relation to tech and AI. Some uses need to be banned. Some uses need to be regulated and approved or not, just as we do with arms, with drugs, with other technologies.
Thank you. We've been mostly talking about human rights and the responsibility of government or companies, but there's also the other side of the coin, so the personal responsibility. How does it play with the governmental responsibility, with the company responsibility? Till what point an individual citizen is responsible for the climate change? How far should we protect our own human rights, boycott, or is it more the responsibility of the governments or of the companies?
Thank you. That's a great question. I think it's all of this. So again, I think that human rights values exist in our personal ethics and how we live our lives. The moment a parent decides how to raise their child, when should they be allowed a mobile phone? When should they be allowed to go on the internet, etc., etc.? They're already actually making decisions about that child's rights and freedoms. And there are dilemmas and balancing acts in all of that. And then governments make the final decision on behalf of all children, and they legislate in child protection laws and criminal laws and so on. But there's a human rights ethic that we all have to... I mean, Eleanor Roosevelt famously said, human rights begin in small places close to home, which I think... And the reason that is such a famous quote is because it's so powerfully true, is that the way we conduct ourselves, the way we relate to our colleagues, our friends, our family, engages all these issues about how much privacy, how much free expression, what is the balance between free speech on the one hand and not denigrating somebody. You know, all of that stuff is very real. And then that's the personal ethics. There's a collective community morality. And then there are political decisions that we make, and including collectively, like to go out and protest because of a genocide somewhere else in the world or because of climate change or whatever. And I believe that there are ethical responsibilities and moral duties for us to do that too, because protesters are human rights defenders. Citizens are human rights defenders. This isn't some sort of esoteric priesthood of... Somebody's telling me that I've spoken too much.
Do we have more pressing questions? Yes. 1, 2, 3, let's say.
So you spoke about how the rights and freedoms to protest are being limited, especially in the UK. But just playing devil's advocate a bit, that's also because protests are interfering with other human rights, like street burnings, interfering with the right to freedom of movement, and paints being thrown at paintings, like limiting the freedom of cultural expression. So how do we find a balance between the freedom to protest and then limiting how it interferes with other human rights?
No, thank you for that. It's important to be devil's advocate because you're quite right. We can't have whole cities just shut down indefinitely and then people can't go to work and school and et cetera, et cetera. But I think that the proportion... So here we come to the concept of proportionality. You know, if street protest is a safety valve, you allow the safety valve, you let the steam out of the kettle. That's a very old-fashioned kettle, but you know what I mean. In other words, you allow, as law enforcement, an element of disruption, and most experienced organisers of protest understand that. You know, they want to cause some disruption because that's how you draw attention to your cause, and then you go home, or then you go to the pub, and then you go home, right? And what you're doing is you're drawing attention to a cause, but your objective is not to alienate the entire electorate or population, because you actually want to win hearts and minds too. So there are tactical issues for protest movements, which have always been the case. You know, the suffragettes used to have terrible rows about how much direct action, whether men should be allowed to participate, whether it's just going to be women, how far you should go, whether you should actually damage property or not. You know, so you've got all these ethical dilemmas within a protest movement, and then you've also got, you're quite right, these are not absolute rights. Your right to protest is not absolute, even when it's nuisance, even when it's not violent, but it's just nuisance, it's just shutting down the traffic in central Amsterdam. Nobody expects that you're going to be allowed to do that indefinitely. But it's proportionality. It's allowing a certain amount of disruption so that people can have their voice, and then people need to go home or be arrested. And some people want to be arrested and will set out to be arrested, and that goes with the territory too, you know. So I think it's about proportionality. There isn't a sort of perfect bright light to this, that creating more and more and more and more law to criminalise more and more innocent normal activity is not, in my view, the way to go, because it will have all sorts of dangerous unintended consequences. One of which is that, you know, a lot of journalists have been caught up in this. Innocent journalists who are literally just reporting on protests have found themselves arrested and detained in England for conspiracy to cause a public nuisance. conspiracy to cause a public nuisance. What does that mean? That means, well, I'm the journalist and I was told there's going to be a protest, so I'm going to go to cover. And then people have been arrested for that and detained for many hours. And the police say, well, they are giving the protesters the oxygen of publicity. Yeah, that's what free speech looks like. Say again? That's their job. Totally. And the job of a journalist with protest is to report what they see and to report the activity and the abuse. It could be protesters behaving badly, it could be police officers behaving badly, but you've got to have journalists able to report on this. Yeah.
When do you think will we reach a turning point on which it will be more profitable in an economic and financial way to take better care for the environment?
On Thursday, the 16th of December, No, I know you didn't mean that. It's a combination of public opinion and political leadership and sanction, actually. It's going back to the gentleman in the front row with the red sweatshirt, that it's transparency and us understanding the problem is part of it, and getting a more detailed understanding of what companies are actually doing. But it goes beyond that. It's got to become less attractive and less profitable to do certain things, and that will only happen with governmental action. Certain activities need to be taxed or regulated or banned, in addition to other activities being promoted, invested in. You know, there are different levers that governments use to affect change behaviour, whether in the public or whether in corporates, right? And the spectrum of policy levers goes, at one end you've got imprisonment and criminal offences, and punitive taxation, and then you've got education, information, transparency, and at the other end you've got positive investment and tax inducements to do this activity and not that activity. And so government and the international community do have a role to play in affecting that kind of change in the corporate world. That becomes more complicated when they are when the corporations are more international than the governments and richer, and have huge lobbying operations and fund politicians for their whole careers. You know, there are corporations that literally find these political candidates when they're still in the student union and fund their careers all the way to becoming Prime Minister of a country, for example. So that is a challenge. And then the other piece is consumer action, which does work sometimes. It did in the anti-apartheid movement, which is an obvious example. It was hugely potent. It was hugely potent when women in Ireland at the supermarket checkout were making a stand on Cape fruit, and so on and so forth. So it's a combination of things, but I'm optimistic.
Right. Do you want to react directly? Yes, and then we have two more questions, and then I'm going to call an end to this.
I agree on what you last saying, but also last week I was in a symposium filled with entrepreneurs. On stage, a civil servant. And the first sentence he mentioned, yes, happy for you that we postponed the CSRD, the implementation of it. Are you happy or not? I said, what? Happy with postponing the CSRD? It's 2 years postponed by the European Commission. I said, but for who are we doing this? And I ruined the whole optimism. I said, but I call it a fight against ourselves.
I think it's a very important point that you make. People working for corporations are human beings too. You know, they have individual consciences, they have families, they have children, they have grandchildren. It's like with the whole Me Too movement. It's, you know, it's like even the stereotype old white man who's sitting in a sexist company has maybe a wife and daughters, and, you know, people are impacted in ways that aren't, you know, immediately transparent. But these are not monoliths. They're made up of individual human beings who surely have concerns too. I mean, if you look at the world of tech and online, there are so many refuseniks now who started out working in Silicon Valley, who are now the ones sounding the warning about advanced AI, about, you know, exposing children to the internet too soon, etc., etc. So I think you're right. There's this kind of very strange dance that goes on between certain mainstream politicians on the one hand and bureaucrats and the supposed captains of industry. That is very weird and artificial, instead of just being honest that we have different expertise, we have different business interests, we have different professional backgrounds, but surely we're all in this together. We don't, you know, we live on this planet and we want to address it. Of course there are debates, there are live debates about how much you can do, how quickly, who pays, and what the transition looks like, including in working class communities and people worried about the refinery and the coal mine and whatever. These are real debates. It's not motherhood and apple pie. It's not easy. But let's not pretend that it isn't ultimately in everyone's interest to tackle this as an emergency.
We had a question there behind the pillar.
Yes, thank you for the lecture. I think you made some very interesting and right points. I also have a law background, and I also do research into the European Court of Human Rights and the prisoners' rights. And what I'm wondering is specifically about the living instrument doctrine, because normally the European Court has used it as a kind of a competence creep. So like they expand their powers, for example, for say same-sex couples, which wasn't probably intended in the first place, but I'm happy they did it. But what I wanted to ask you is, do you think it's possible that specifically on the stage of climate warming, that they take a less strong stance? So now in the Klimaatszene, in this case in Switzerland, they've been quite, or Austria maybe, they took quite a strong stance, but with Europe leaning more right, do you think at some point they're like, we're not going to be the beacon, we're not going to break on this, we're going to be less strong on this, and we're just going to all push it into the margin of appreciation?
That's very interesting. I mean, so at the moment, there's a wider margin of appreciation over what measures you take, but not a wide margin of appreciation over needing to take measures, which I think is which is actually a reasonable approach. Because if we were talking about, you know, in the last comment we were talking about these, that there are real decisions. You know, whose jobs are going to be axed tomorrow, and you know, these are very, very real. And how much will the cost of fuel be in the transition, and who's going to pay? And you know, these are very, very real challenges, and they are political and they are economic. And a court is not the most qualified arena to be very prescriptive about those polycentric social and economic prescriptions. But a court is qualified to say, here is the science, here are the obligations that you states have already signed up to, and you need to act on them. Now, we're not going to tell you exactly how to act, but you can't do nothing, and you can't do next to nothing, which is what some of you have been doing. And I think that is that's a very legitimate role of a court, including an international court in Strasbourg. Now, as to whether, you know, the Klimaatszene Swiss case is the high point and there's going to be a backlash and they're going to go backwards, I hope not, but that is about political advocacy as well as jurisprudence, isn't it? Because courts don't sit in a vacuum, and particularly a court like the Strasbourg court, where, you know, the judges are, you know, the model of selection is, you know, the different countries put up 3 candidates, but they're all signed off by the government, and then they go to a committee in the Parliamentary Assembly of the Council of Europe, and then one of the three is selected. So it's not devoid of politics, and so if things go too far to the right, that's bound to have an effect, not just on the choices of who becomes a judge, but on the kind of how a judge feels about all these issues we've been discussing, and whether they feel legitimate, whether they feel scared. I mean, we had, in recent years in the UK, we had some terrible headlines, particularly around Brexit. We had pictures of judges on the front page of the Daily Mail, and they were called enemies of the people, because of some of the decisions they were making about the Brexit process, and they're human. And don't tell me that isn't at some point going to have an effect. So that's why these kind of conversations have to be multidisciplinary. It's not just jurisprudence, it's also advocacy, campaigning, journalism, education. Let's be honest about the context and how we have to create the political environment to save the physical one.
Okay, we have one final question by Andrew.
No pressure to come up with the perfect question for the lot.
Jesus Christ.
Those are good last words.
Just after Easter as well. So, my question is about the relationship between international human rights law and international criminal law. And in particular, what I'm thinking about is the campaign over multiple decades, but in particular in the last 15 years, to criminalize international environmental destruction under the label of ecocide, to have that recognized as a fifth crime in the Rome Statutes. And I wonder what your views are on the campaign around ecocide and on this relationship in terms of international criminal law with human rights law as well.
So we've been talking a lot today about the relationship between human rights law and environmental law and the climate challenge, but there are lots of other intersections, including the intersection between the law, international humanitarian law, the law of war, and human rights law. And I think the cross-fertilization is nearly always quite healthy. And I think that I would say this as a human rights lawyer, but I think that human rights law has been a very, very positive influence on these other areas of law, whether environmental or international humanitarian, and international criminal law is difficult because it's a particular challenge, it's a particular symbol for the hawks, for the nationalists. And, we've got the perennial problem of, the US, even in the lovely Obama-Biden days, not putting its citizens in the jurisdiction of the International Criminal Court and so on. But I think the campaign for ecocide is a good conversation to be having because it draws attention to the gravity of what we're facing. Whether it will succeed anytime soon, I don't know, but it's the right kind of conversation to be having. And that's the thing about any campaign and any kind of protest. You think you're not winning, but actually you're achieving so much. Years ago in London, we had all these protests about the Iraq War, which was an illegal war and a really stupid war in my view. And millions of people were taken to the streets and nothing happened. The war continued, and some people thought, what was that? It was pointless. It wasn't pointless because it bred a movement that continues actually to this day. It bred a generation of people, some of whom, were responsible for a moment in the Labour Party, which was the moment that I joined, So it's very difficult to tell the positive ripples and repercussions of these campaigns and these movements. Criminal law and criminal sanction does have a place in taking any kind of grave abuse seriously, whether it's war crimes. So I think that it's the right discussion to be having. I don't put my eggs in that basket, if I'm honest, but that doesn't, I don't see it coming anytime soon, and I don't see it as the headline issue in this space. But I wouldn't denigrate the campaign, because even while those campaigns and conversations are happening, they are educating people and drawing attention to the gravity of the challenge.
Okay, well, it's maybe nice that we're ending on a message of hope that protesting works sometimes. Thank you very much, you, everybody, for your questions and for being here, but most of all to Shami for her lovely lecture and then for hanging out with us for another hour or so. So join me in thanking our speaker. And I'm reliably informed that there are drinks at the back of the room for after this talk, so I hope to see you there.